Good morning, my true crime lovelies. How are you? Or good afternoon, or good evening, or good whatever time it is when you watch this. I hope you are as lovely in life as you are in my mind. All right, I'm not going to bury the lead. There's a lot of stuff happening in the family court with Sarah Boone. I'm going to go through all the docs, but I know some of y'all don't like the docs. So I will give you the highlights first for those who just want to hit it and quit it. And then we'll go into all the nitty gritty for all the nosy folks after my own heart. But first, I want to thank all of my lovely members. See you on the other side. Okay. So, really quickly, the last time we heard from the court was the minutes after the last conference that Brian, actually, let me make myself bigger so you can see me, was the conference that Brian and Sarah had, right? That I tried to get into. I got in for a second, but not on their case. And so, since then, Sarah filed a bunch of motions. Surprise, surprise. The judge denied all of her motions except for one, the withdrawal motion, right? Where she kind of fired off all of those motions right before the last hearing, and one of them was a motion to withdraw, and that order was granted. Girl, take it out of here. That was the first one where she was demanding full child support, full alimony. She took that out, and then Sarah, and then she submitted another one for alimony and then child support, not to leave the house, but to be designated to her, I guess, and it spent according to how she says it should be spent. Never mind, she hasn't been paying any child support since 2020 when she got arrested. It's always all about her. She pretends it's about her son, but if you read it at face value, it clearly is not about her son, right? The other thing is, she is just on a terror, just an ego fueled terror. Brian has submitted some financials, which we'll go over. It turns out he has been unemployed since 2022. If you've been following the text messages, you know that Sarah has had her flying monkeys contacting him, harassing him about payment, putting money on her commissary. She calls him POS, former husband, right? So now that I knew he was unemployed in 2022. I didn't know about 23 or 24, and now it's in writing. He has not been employed, so I feel horrible that he's been contacted. And some of you will be like, "Oh, it's not really harassment. They were just nudging him," but he doesn't owe her anything, and they shouldn't be nudging him. He doesn't owe her anything. They are no longer married. Alimony, there's nowhere in the divorce, the dissolution of marriage documents that says alimony goes to the person even if they're incarcerated, right? And he had filed something in 2022 when he lost his job to eliminate or reduce alimony. And that is what we're going to go to court for. You see how I invited us along? That's what we're going to go to court for this year, to get it sorted out once and for all. And the desperation from Sarah is real. So we have that, and then we've got a no nonsense pre-trial prep document from our good judge, our learned judge. And so I'm going to go through all of that with you. But if you just wanted to know if any of her motions got granted for Owens to cough up her documents, that was denied. Judge has no jurisdiction, which is what I thought. Now, in this case, she should have got with Daryl Brooks, Sarah, because she has no personal jurisdiction over Owen, so she can't make him do anything. And then her motion for counsel for free also was denied. But let's go back. Let's look at the order from the last hearing so we all start on the same page, if you're nosy like me. Okay, so here we go. Let me add it to the screen. Good to have that monitor over there. Okay, here we go. Order after case management conference on March 26, 2025. This cause having come on March 26, 2025 for consideration during a case management conference. The parties have appeared and the court having reviewed the court file and been duly advised in the premises finds and orders as follows. So they all appeared virtually for the case management. Petitioner advised he's ready. He's ready for trial for a final hearing. Whatever needs to happen, he's ready to go. Let us get a decision on eliminating or reducing this alimony for my now convicted ex-wife. The court noted that there were pending motions that needed to be heard prior to trial as follows. Motion for court orders to obtain and present evidence for pro se respondent to provide court. We know that was written by Sarah, not just because it says so, pro se respondent, but because it's so detailed in this damn title, to provide court. I think she's adding to provide court of like, court, go ahead and give me an order, otherwise I can't give this to you. And then motion, and they put in brackets to review, motion to withdraw. I think there's a typo there. Motion to be heard during case management conference on Wednesday, March 26th. I think maybe there was at one point under the old, or not the old judge, the prior judge, a time where she did not get to speak. So I'm thinking that is what that is referencing, because I don't know why you would need a motion to be heard. And then amended motion to be heard during case management conference on March 26th. So she's just like firing off documents, because there's no reason why you need to submit two on the same day. Like, just take your time, review it, feel confident about it. Oh, wait, no, her flying monkeys were telling her what we were saying on YouTube, so she corrected it. Anyway, requested relief to be ordered by court from Brian C. Boone, so she's begging for money. In the conference, on this date that we're talking about, respondent made an ore tennis motion for mediation, which we remember from Kranick, that's an oral argument, to which petitioner objected and the court denied. Right, she blew it for mediation, even though she's saying they never did it. It's because she refused. That was the letter where she's like, I have cancer, I can't schedule it. If I do schedule it, can I reschedule it? What happens if they have to be, like, she was asking Brian's attorney for legal advice, basically. Ma'am, cough up some dates. If you can't make those dates, then we'll cross that bridge when we get to it. But it's that control thing with Sarah. She doesn't want to give you anything. She just wants to torture you, basically. Like, she asked 1,000,001 questions, but not once in there did she say, I have no problem with mediation. Let's set up these dates. Please be mindful. I have cancer and I may need to reschedule those, right? Letting the attorney know, but then also she would need to let the judge know, the court know, that she's asking for a continuance. Sorry, I'm a little nasally. I have my vaporizer running. Hopefully I think it's a pregnancy. Like, anyway. The parties are further ordered to file the certificates of compliance with updated mandatory disclosures by Monday, May 5th, 2025. So they would have been told that orally on the record, even though we're just saying it. A 45-minute pre-trial conference was coordinated for May 29th so that the motions listed above could be heard prior to trial. The court will issue a pre-trial conference, right? So those motions have not been heard, done and ordered. This, I normally don't go over the certificate of service, but you'll see Sarah has not corrected her address. Lowell Correctional Institution, main unit. We know now she's in the annex, and she was moved there. Oh, wait, this came out today, or this came out last Friday. She moved on the 4th. Why she hasn't updated it in the records, I am not sure, but if they were updated, it would be corrected here, because this just came out Friday. Okay, so then let's look at and I like to go to through the details, because sometimes there are rumors on YouTube and people hear it and they run with it, and then it's like, well, where's the source document? So I like to show you guys my source documents, because I'm just not out here making up stuff. Not that you guys think I am, but if someone challenges it, you can be like, oh, it was on this document, blah, 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 you know? Um, and you can also make sure that the way I'm understanding it is the way that you're understanding it, because we all have different comprehension levels. And you could be Einstein and be like, Tanika, not even Einstein, you don't have to be, you could be whoever and be like, Tanika, girl, that is not how I read that document. So this way we all are on the same page. So uniform order setting pretrial conference and for non-jury trial. The trial date, this case will be set for a trial date within a trial period determined at the pretrial conference. So we're not going to know until that May 29th date what the trial date is, right? The case has been noticed for a trial length of 2 hours. So it shouldn't be longer than 2 hours. Any contested motions to continue the trial shall be filed prior to the pre-trial conference. So if Sarah needs more time to gather money to get copies or whatever else, she needs to file a motion for continuance prior to May 29th. Then here's all of the information. I gotta do some research. I want to write the judge or the judicial assistant and see if I can actually, in the interest of public, see if I can join. There are no children in there. Like it says here, children are not permitted without prior court order. And they're appearing via video conference. So I'm hoping, but we'll see. Anyway, at the meeting, the attorneys or the self-represented litigants shall discuss and attempt to settle unresolved issues. Partial settlements are encouraged. So hopefully they can at least settle the foolishness with the child support. There's no way that there should be a child support fund that Sarah gets to direct when she did nothing to earn that money, and her judgment is questionable. Determine a date at which to produce, examine, and initial on back of the evidence tags for every evidentiary exhibit intended to be offered at trial. Which exhibits can be admitted as joint exhibits, which exhibits can be admitted without objection, and for exhibits to which objection will be made, specify the grounds of each objection. All objections are to be included on each party's exhibit schedule. So it will be on the exhibit on the tag and also on a schedule. So this, if Sarah is paying attention, will be beneficial to her, because joint exhibits would be the dissolution of marriage agreement, the parenting plan, anything else that was filed on behalf of that original case would be a joint exhibit, and she could ask Brian and his attorney for a copy of that. Hopefully they would give it to her for free, right? So she doesn't have to worry about it. And then also she doesn't have to pay for certified copies because they will have entered it. They would have paid for that. Do you know what I mean? So, but she's like, will cut off her nose to spite her face. So, flying monkeys, let your girl know that this is her opportunity to get some of those documents that she doesn't have the money to pay for. So, and any other things that would be like, we'll get to it, but Brian is alleging that he has loaned Sarah $20,000. So does he have receipts? Did he transfer that? And it also appeared on his 2022 filing. So is it like he transferred it into the prison? Is it he paid for her car registration and tags and insurance? And I don't know if they do smog in Florida. California is the last place I owned a car. We had to do a smog check. Paying for her storage, paying for movers to pack stuff out of her apartment in Winter Park. Does he have receipts for all of that? That tallies up to $20,000. Now, she will probably object, but she'll have to write on the back why she's objecting, and then she'll have to have an exhibit schedule and put on there what her objections are. They're going to review the witness list. So, I don't know, is Brian going to call Christina Pena so she can explain her text messages to him? Why was it any of her business? Why did she feel it was appropriate to harass him? Does he need to get a restraining order? I don't know if he will, but you know what I mean. And so I'm trying to think of any other witnesses. I don't know. the text messages, I guess, how would they get that entered in? So they would probably need a custodian of record if they're going to enter in the text messages. I don't believe they can read the text messages between like Sarah and Lana, because that would be hearsay. She is not a party opponent, right? Party opponent is an exception to the hearsay rule. So anything she wrote to Brian is free game to come into evidence. All the harassing, crazy messages that she sent him, demanding coffee and other things while he's an unemployed single parent. So identify, discuss, clarify, and narrow the remaining issues to be tried. So the big one is the alimony. So I think they're going to have to clarify. She has given no case citations of, well, no applicable case citations, right? Because she's given some, they don't apply to her, and maybe I'll do a separate video on that. I'm gonna research it, if whether it becomes a video is something else or not. If it's really juicy, it'll probably become a video. But so she's got to cite something of like what gives the precedence or authority to the judge to rule in her favor. Exchange proposed parenting plans, if any. So she's going to have to put in a parenting plan, right? They have an existing one. It's no longer valid because she's incarcerated. She didn't honor the other one anyway. One of them was she wasn't meant to drink around her son or be drunk in the presence of her son, and we know that didn't happen. But anyway, so whatever that looks like for her, what she thinks it looks like, he's 14 now. So if there's any like family law folks, particularly in Florida, but just in general, let us know. Like, does he have a say? Does he have to visit with her? Exchange all proposed child support guidelines, including guidelines and calculations for retroactive support and arrearages. Now, I don't think she'll ever be paying it, but if I were Brian's attorney, and mind you, I'm nobody's attorney because I'm not an attorney, I would be listing out how much she owes him in child support, just so you have that number as a negotiating tool, right? So since February 25th, 2025, or 2020, she has not contributed to the welfare of the child. He has done that solely. So she owes him child support. What they did in the court order prior with Michael Dean was they just stopped it, in that Brian didn't have to pay her. They didn't attribute any to her. And they said it's due to her incarceration. But girl, you're in there for life now. So you have a job. Cough up some coins. Discuss and stipulate to facts that will require no proof. Things like they were married, they got divorced, they share a child in common. Identify all issues of law, procedure, or evidence to be decided by the court before or during trial. So one of the issues of law is, do you owe an incarcerated person alimony? Do you owe an incarcerated person child support, as she is attesting? Reduce to writing and sign a list of all matters requested to be judicially noticed. So just make a list, basically. We're not going to go round and round about it. Just make a simple list for the court in advance of that event. If there is property to be distributed, prepare a joint equitable distribution spreadsheet, including each party's suggested value of marital and non-marital, real and personal. So I don't think that really applies. Her property that was in her apartment, her heirlooms, that one, she says George destroyed, two, she says Brian did not preserve, that was all post divorce. So I don't think that's going to come into play. Like, he's not going to owe her a dollar amount for her junk. Discuss, and the same thing for the car, discuss and attempt to agree on other matters that will lead to a more orderly and expeditious trial. We're going to keep it to 2 hours, so get it all the way together, including the preparation of the required joint pretrial statement. What is that, you say? Well, let's see. Following the meeting of attorneys and or self-represented parties, Sarah, the statement shall be signed by all attorneys and self-represented parties, Sarah, filed with a copy delivered to the judge no later than 5 days before the pretrial conference. So if the conference is the 29th, it's got to be in by the 24th. this joint pretrial, and it's mandatory. To the extent the parties differ as to how portions of the statement should read, the differing views should be set forth in the statement. Like, she thinks it's this, he thinks it's this, list that out. What are the differing views? She thinks she should get full alimony, the $61,000, and he thinks she should get nan. Niche. Zip. Zilch. Zero. The court expects parties to reach, and this is bold, all underlined, to reach reasonable stipulations regarding the facts and issues in this case. The memorandum shall contain the following for each area: A and B for dissolution of marriage cases and paternity cases. So it's a dissolution of marriage case. I don't believe there's any paternity, whether this is an original action or whether this is a supplemental proceeding. So this is supplemental. The original action was 2018. For child support, amount of child support requested, any retroactive arrearage or credit for support payments. Sorry. The children. Current time sharing practice, 0. And whether the time sharing is in place by court order or by agreement of the parties. I don't know that it's an agreement of the parties. It's due to the actions of one of the parties that she has no parenting time, right? Gross and net income of each party for the purpose of setting child support and the basis for the amount of income, pay stub, W-2, federal income tax return, etc. Like, where's the source document? For child support, amount requested and any... Oh, I read that one. Medical, dental, vision insurance. So Brian is covering all of that. And mind you, he's unemployed, so he's covering that out of pocket 100%. Because even if you have the Affordable Care Act, right, that's still out of pocket. Any special needs included but not limited to medical, emotion, or education. So we know that their son has needed therapy from being bullied since the age of 9 because of his mother. So presumably he's continuing with that therapy and getting the emotional support that he needs there, especially since his mom is continuing to harass him. Proposed contact. I wonder if those text messages can come into the evidence, the messages that she sends to her son. I don't know though, because he's not a party. There's got to be some way to get that in there. But anyway, GAL report. So the guardian ad litem, the lawyer that's assigned for the child, report and any agreement about whether the court may consider the GAL report and any stipulations to hearsay in the report. So I'm guessing Sarah's going to oppose whatever is in that report. And here they're saying stipulations to hearsay. So if coming in like, son said, mom said, blah, blah, blah. So are they going to allow that in or are they not? But she's a party to the matter. So I don't know. It'll be interesting. For paternity cases only, that we don't have that. And then alimony, marriage, date and place of marriage, date of separation, amount of alimony proposed. So Sarah's going to go back to the amount. And this is going to be her downfall because she might have wiggle room if she's willing to like reduce it to $100 a month. Do you know? Because she's being reasonable. But if she sticks to the $1,000 a month and goes back and asks for $61,000, I think the judge is just gonna like have her meet her hand. And we're in April, at the end of April now. So this is contractually the last month that he would have been responsible for alimony had she not been arrested and convicted of murder. Nature of the alimony, i.e. specific type, term, and amount proposed by each party. Again, if she has any sense, she'll reduce it to like $100. Right? She's working in there. I think, what is the daily rate there? $30 now? I know it was like $3, $2.90 in jail. Let's just look it up really fast. Florida prison or Florida DOC pay to stay. Daily rate. $50 per day. So Florida's pay to stay statute, they pay $50 a day. Jeez. Well, I don't think alimony should cover that. I don't know how they work that out, but what is that? That's like $300 a month, right? If it's 30, no, that's not right. It's more. You have 30 days. Is it 3,000? Wait, my brain is broken. 1,500. Okay, yes, broken brain. Still nothing to sneeze at. I think Brian should pay for that? No, Brian didn't murder anybody. Okay. So real property, there's no real property. They sorted that out in the original. She signed a quit claim. He paid her, I think it was $10,000. It's in the videos, Boone v. Boone, if anybody's curious. I'm not going to look it up right now though. Wait. Um, Personal property, no. Debt, that was already sorted out. He paid her $22,000 for half of the credit card debt that they acquired together. I think it was her credit cards, but as part of the divorce, he covered half of them. Attorney's fees and costs. So this is the thing. He's asking for attorney's fees. So because she wouldn't do mediation, I have so many thoughts on this. But anyway, she could end up, I don't know how she'd pay it, but she could end up with that bill for his attorney's fees. So keep writing those motions, girl, because you are running up that bill. Trial exhibits witnesses, a witness list giving names and addresses of all individuals who may be called by each party to provide testimony, including impeachment witnesses and expert witnesses. I would not be surprised if they called up Christina and Lana because they've inserted themselves into it. So now they've become witnesses. They have testimony. You contacted Brian. Yeah. Maybe, I don't know. I'm trying to think about the parenting thing. I would think there would be witnesses. I'm just drawing a blank on who they might be. Let me know if you have an idea of who those witnesses might be. Detailed schedule of all photographs, exhibits, and documentary evidence that a party proposes to use, including impeachment and expert witnesses. Yikes. The schedule should include enough information to identify each specific document. General categories of documents are not permitted. She wants specificity. Composite exhibits are permitted if they are specifically identified. All exhibits being presented should be pre-marked before the trial date. Instructions on how to properly pre-mark evidence and tags can be obtained through the clerk of courts. So one of her flying monkeys is going to have to get that because it's not like she can call the clerk of courts. But that you've got over, 30 days now. So get it together. I feel like they lay these things out plainly for her, but she's going to come up with an excuse to be a victim. Oh, I'm in jail. I'm in prison. I can't do da 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 da. You have to leverage your resources. You figure out how to get coffee and coffee money and packages. So figure it the F out, ma'am. A joint equitable distribution spreadsheet, petitioner or petitioner's counsel. The joint equitable distribution spreadsheet shall be mailed to the court and to both parties at the same time, at least 5 days prior. So again, 5 days before May 29th. Miscellaneous requests for amendments to the pleadings. If this is a modification, filing date and description of the prior pleading relevant to the current proceedings. Example, final judgment, supplemental petition, etc. So it'll be the dissolution of marriage and that whole packet, and then it'll also be his motion to eliminate or reduce alimony. Any issue the party wants to take up at trial that is not addressed above. So it's not going to be the car, Sarah. It's not going to be your stuff from storage. That is not, the court doesn't have jurisdiction over that. Any outstanding motion. So we went over that in the last document. All of those motions that she has will be decided before they get to the actual hearing/trial. Requests for judicial notice, citations, or copies of any case law to be argued at time of trial. So she's going to have a hard time getting the copy, so it'll be citations. whether there will be a court reporter and or interpreter, and any agreement between the parties concerning the sharing of the cost. So we know she's not going to be able to pay for that, but I hope Brian has a court reporter there documenting it, because then you can get the transcripts from that. Good faith estimate of the time needed for both parties to try the case. So it sounds like they went over that. It was 2 hours. I'm imagining Brian's going to use an hour and a half and Sarah's going to use 30 minutes talking about absolutely irrelevant things, but I could be wrong. A new executed updated financial affidavit. Okay, so we have all that. Then we've got some stern warnings, refusal to cooperate. If a party refuses to cooperate with the filing of joint pretrial, each party must file its own pretrial. So if Sarah does not want to cooperate with Brian's attorney, he doesn't have to go back and forth with her. He doesn't have to do that dance that she tried to do with the mediation, right? He can just say, fine, you do yours, we'll do ours, see you in court. Discovery cutoff deadline. All discovery shall close on the day prior to the pretrial conference unless extended by court order. And that's cutting it really close, because you could potentially give your opposing side, the opposing party, discovery the day before. Joint stipulations without court order are not sufficient to modify the discovery cutoff deadline. So she's like, you're going to come back to me and I'm going to let you know. Motions cut off. All motions in limine or to exclude witnesses' evidence or other motions directed to the conduct of the trial for which grounds then exist must be filed and copies delivered to opposing counsel or self-represented litigants at least 5 days before. So it has to be delivered. So because she's in jail, she needs to back that up. Back that ass up. She needs to back that up so that they receive it by 5 days. Nobody cares that you're in prison. You understand what the guidelines are. You need to plan accordingly. Trial briefs. Trial briefs are optional, but if one is to be filed, the original should be filed and Chambers copy delivered, so the court's copy, and received by the judge not later than 5 days before the beginning of trial. If mailed, allow at least an additional 5 working days for mailing and delivery prior to the deadline. So that's 10 days for free people. It's going to be, I would say Sarah should count on 15 days. So she's coming up on that. She should have a trial brief shortly, because it would be 15 days. Oh wait, is this for before the pre-trial conference, right? Yeah, so 15 days before May 29th. Notification of settlement. If they settle, that's not going to happen. Modification of order for good cause. Those pretrial statement, joint pretrial statement, time limits, witness list, evidence schedules can be modified upon motion showing good cause, not just a random cause, Sarah. A good cause. Sanctions, bold, underlined. Sanctions is all capped. Unexcused failure of counsel or unrepresented party to attend the meeting of attorneys required herein. Excuse me. The pretrial conference or trial, or to comply with the requirements of this order, will subject offending counsel or party to appropriate sanctions, Sarah, which may include contempt, dismissal, default, striking of pleadings, exclusion of evidence, assessment fees or costs, and other sanctions. Her worst case scenario, that if she's in contempt, that it defaults to Brian, she owes him all of his attorney fees and she gets nothing. So hopefully whoever is flying for her now will relay that to her. Again, it goes out to Sarah at the wrong address. It's on tablet, so I'm not sure how significant that is. And then Nancy Weber is also helping Josh Martell to represent Brian. I was going to say defend, but he's not the defendant. Or there's no defendant. It's a family case. But you know what I mean. So then it goes into like, what do you need for disability and those sorts of things. Let's take a break because I've got a nose situation and I need to wash my hands. We'll be right back. Tay. Okay, so that is all there. Let's go on to certificate of compliance with additional updated mandatory disclosure. Brian is on it because this is early. He has until May 5th, and he's got it turned in already as of Friday, which I think was April 25th. So I've highlighted some things. I'm not going to go through it all. You are welcome to pause and stop and screenshot and all that fun stuff, but I just want to hit the highlights because it's a lot of words. Certificate of compliance with additional updated mandatory disclosure comes now. The petitioner, Brian C. Boone. So, and it has all the rules under which these things are being asked or demanded. So for the past 3 years, they're asking for federal and state personal income tax returns, gift tax returns. So like if his parents are giving him, I think you can give like up to $100,000 as gift tax without being dinged, something like that. Don't quote me. It's been a while since I've been in banking. Foreign tax returns filed by the party or on the party's behalf for the past 3 years. Petitioner has been unemployed for the past 3 years and has not filed income tax returns for 2022, 23, or 24. But his ex-wife has had strangers calling him, harassing him for coffee money. So then W-2, none exist. Pay stubs, none exist. A statement by the producing party identifying the amount and source of all income received from any source during the 6 months preceding the compliance, none exist. Credit reports, loan applications, financial statements, credit reports, or any other form of financial disclosure prepared or used within 24 months. For initial or some, so this says none exist. Credit reports is underlined. I don't know how credit reports don't exist. I'm not sure what Brian and his attorney are doing there, because that whether you have a job or not, you have a credit report, right? So all deeds evidencing any ownership in property held at any time during the last 3 years. So he owns property they said it during the trial in Florida. I'm not going to keep repeating it because let them have their piece, but he's provided a copy of the general warranty deed. Petitioner has, so all periodic statements for the last 12 months, petitioner has provided statements for the following account and time periods. It says choiced, but I'm pretty sure they mean a trust checking, perhaps set up by his parents. So they provided statements from April 26, 2024 to March 27, 2025. So 12 months worth. Brokerage account statements, none exist. Which I don't know. I mean, maybe he cashed them all out and he's living on them, but most of us have a brokerage account of some sort. None exist. And then his retirement stuff. So profit sharing, retirement, deferred compensation, pension plan, for example, an IRA or an IRA, 401k, 403b, SEP, KEOG, or other similar. And deferred compensation. So like I'm on a bonus plan and a deferred compensation. It's called long-term incentive. So like, for example, I'll get $10,000 as part of my compensation package, but I can't access it in full. It's not fully vested for 5 years. So each year, some of it becomes available to me as long as I stay employed with my company. So that would be deferred, an example of deferred compensation. He's not employed, so he doesn't have that. Petitioner has provided statements for the following account and time periods. Windstream 401k plan from April 1 to March 31st. So this would be, as part of their marriage dissolution, they did not share or split 401k. Sometimes you would have it, like, especially if it gets complicated, but like if he had a job that started during his marriage, she had a job that started during his marriage, they would jointly own or have rights to that money, not technically own, but have rights to that money. For these two, he kept his 401k, she kept her 401k. It gets a little more complicated. Like if he had worked that wherever he was working 10 years before they got married and then They got married. So the 10 years prior, she would not have access to that money. She would not have any rights to it. But then how do you figure out what it is? So that's when you hire like a forensic accountant. They're expensive. So a lot of people usually will just stipulate like X amount of dollars belong to him. It's when you get those really nasty divorces and you're just dragging the person over the coals. You'd rather force them to spend money on a forensic accountant to get every single penny. Like sometimes, know when to fold them, know when to hold them, know when to walk away, know when to run. You never count your money. When you're sitting at the table, there'll be time enough for counting. When the dealing's done, Sarah's going to count. She's going to count. Anyway, petitioner has provided copies of insurance cards for himself and minor child, so he's paying for that. That is an out-of-pocket expense that Sarah is not sharing in. And then all promissory notes. So the rest of this, I'm going to go through it. None exist. You can screenshot or stop or however you want to roll. Any court orders directing a party to pay or receive spousal or child support. Respondent has provided copies of the party's final judgment of dissolution of marriage, filed June 15th, 2018, and supplemental petition for the modification of final judgment, filed April 12th, 2022. And for those of you who are wondering, I believe Brian moved in 23 to where he is now. So yeah. And then that's intentionally left blank. It's sent to Sarah at the main unit in Lowell. And then here, so for those of us who've been nosy in the text messages, you know who Peter John Gunthel is of Delapine Creative. Well, why is his name appearing on this legal document from Brian's attorney to the court? A copy of the foregoing has been furnished by electronic mail through the Florida e-portal to Peter John Gunthel, professional representative for the respondent. I blocked out his email and I blocked out most of this, but I thought this was funny because the start of it is Burger Boy. So anybody with some free time to research what Peter John Gunthel has to do with Burger Boy, let us know. But it's weird, right? Like, so is he the one filing these things for Sarah? Because I had to go back and look. I don't see anywhere where where it's publicly submitted that he's the representative. So maybe that's not a thing that's on the docket publicly, but clearly he's let Mr. Martell and his law firm know that he is involved, and so they've sent a copy of this to him. And then the final audit report. So they're doing eDoc signatures, I guess. Well, yeah, because Brian lives in a different place. And so it has all the information on there. Okay, let's get to the financials, shall we? Family law financial affidavit, long form. I just want to show you guys this part. So he's 49, software developer, currently looking for a job, but he's unemployed in the $60,000 to $80,000 range. I'm not here to dollar shame anybody. If that works for him in Florida, that works for him in Florida. But the fact that she's asking for almost a year's worth of salary is ridiculous. Ridiculous, as she would say. She wants 61,000 and he's looking for a job that pays between 60 and 80. Where is he meant to get this money to send to her for Zuzus and Wham Whams that she can't even access more than $300 at a time in her account? What is going on in her mind? I think it's just spite. It's just spite. She doesn't care about her son's well-being. She doesn't care about what's fair and equitable. She is just like, you owe me. You are going to pay me, irrespective of everything else. So here's the household for his place in Florida, what his expenses are. His average monthly expenses are about $1,200. That's like cable, meals outside the home, food and home supplies, milk, garbage bags, whatever miscellaneous household stuff, like if you need repairs and maintenance are here. Fuel, oil or natural gas, $20. I wish. Electricity, $180. Mine is so sky high. It's like ridiculous. I'm jealous of these prices. But I don't know if it's New York. I don't know if it's because I'm in the penthouse and one side is all glass, but baby, I I wish I had like a $200 total utility bill um, per month. So $1,200 for his home expenses, automobile, gas and oil, $50. Auto tags and emissions, $5. So I'm guessing he's averaging it like maybe at $60 a year, right? It says estimate. And he's just making it a monthly, and then $100 for monthly insurance, so $155 a month. Expenses for children, common to both parties. Allowances, he gets $40. Oh, clothing and uniforms, 50. Entertainment, so he's got some pocket change, movies, parties, etc. Go to a party, get a gift, monthly vitamins, monthly beauty parlor. Do they still say beauty parlor, barbershop? Keeping it tight, keeping it right. No orthodontics, so I guess he didn't need braces. Cosmetics, toiletries, sundries. So I'm thinking that also includes like if you have to go to the dermatologist and get like a little, I don't know, Claritin or not Claritin. What is it? I'm thinking of Clara something. There's just different. I think it's different. It's like anti-acne gel, little things like that. Maybe well, deodorant. Maybe he's shaving. So 155 for the son a month. And then pet expenses, $50, which is also cheap if that's just food. I'm guessing he doesn't have insurance for the pet because my pet insurance for both the dog, even for one of the dogs, is more than that. But if you're unemployed, you got to figure out where your priorities are. So total monthly expenses 1,500, and then the asset. So here he gets 1,300. Oh no, it's saying the current fair market value of the trust checking is $1,300. So I'm usually you would get like a monthly stipend or payment from your trust. So maybe he's getting about 1,300 a month, and that's covering his expenses, right? So money lent to Sarah Boone, respondent owes petitioner in excess of 20,000. So they put that as an estimate. This was also on the 2022 modification request, and so I'm thinking he's loaned it to her since she's been incarcerated. Now, did it all go to Zuzu's and Wham Whams? I don't know. Maybe it's also part of the car registration tags. A bunch of people were like, you don't have to register your car if it's not parked on the street. You do have to register it unless it's salvaged. Your car has to be registered. um and then, at least in California and New York, I did not look up Florida, but whoever was saying it wasn't in Florida either. Then his home, so this indicate its estimated value is at 300,000. He's listing it under assets, which leads me to believe he owns it free and clear, but we'll get to one more page to solidify where I'm coming from with that. He's 2018 Honda CRV. So he bought a used car because the last time we saw him, he had the Prius, right, on the body cam footage, which was in 2020. So he bought a used car, a 2018 Honda CRV. So he's frugal. I mean, he's not out here like, oh, I got an Escalade, So he's being financially responsible for a single parent. Let me say it like that. And then Merrill 401k plan balance as of statement closing March 31st, 57,000. So that's the second 401k. The other one was like Windmill or something. I don't know why it's not also listed here, but I'm not a forensic accountant. So furniture and furnishings, $5,000. He shouldn't be expected to sell that. So his total assets are about 410,000. We'll just say about 500,000, right? And then here, the liabilities. See, there's no mortgage. So I think he probably, because remember we went over his house, because I'm nosy. He was upside down for a while in his home, and he had been threatened. Foreclosure had been threatened. And then when he sold it, he actually sold it at a profit. So he could have free and clear covered that, like paid off that mortgage and purchased this house cash, which would put him in a better financial situation. He could also take out a HELOC on that. What is it? Home equity line of credit and some other. It's not listed here, but I mean, if push came to shove. And I'm sure his parents also help him with his son, because that was one of the reasons for moving, at least for physical support of, having a babysitter or seeing family, having an emotional support system instead of just the two of them alone in Winter Park battling all the bullies. So, yeah. And then he puts here child support guidelines worksheet. A child support guidelines worksheet is or will be filed in this case. This case involves the establishment or modification of child support. So it does, because Sarah's bringing that into the picture, right? She's asking, first she asked for just child support outright while she was in prison. And then she asked for like a pot to be designated, not given to her, but used to buy gifts for her son and gifts to herself from her son for Mother's Day. You can't make this shit up. Okay, let's get into the motions. We'll start with the positive. Order granting respondent's motion to withdraw. So she filed it. It was on the 20th. It was filed on the 23rd of March. Motion to withdraw is granted. Motion for review is hereby stricken and will not be considered by this court. So she was filing multiple things on the 20th. Yeah, so that one is no good, no bueno. And then we have this order denying respondent's motion to compel former defense counsel James S. Owens to surrender respondent's entire family case file filed on April 22nd, 2025. This cause, having come for consideration in chambers on respondent's motion to compel former defense counsel James S. Owens to surrender respondent's entire family, and then they just put motion. And the court having reviewed the court file and being duly advised in the premises finds and orders as follows. I'm trying to sit up straight. The motion is denied. Denied. I wish we had a stamp. Denied. Respondent cites no statutory or other legal authority for the relief being requested. The judge has no jurisdiction over her criminal defense attorney. So done and ordered the 28th day of April. Certificate of service sent to the main jail. So this is what I'm saying here. It's Brian, Sarah, Joshua, and Nancy from the Martell law firm. But now we don't see Peter on here. So either the court doesn't know about Peter or they don't acknowledge legal representatives. But it's noticeably on all of the filings from the Martell law firm. So, and there's no authority that she didn't cite. She didn't say, if you guys remember Judge Everett, when Donna was trying to get the jail to do something, Donna's attorney, and Judge Everett was like, on what authority do I have to do that? Because you have to list it out, and Sarah didn't list it. She just sent this emotional tirade of like, tell him to give me my stuff back. Well, that doesn't work in a court of law. Okay, order denying respondent's motion for appointment of counsel by the court for respondent Sarah K. Boone, filed on April 22nd, 2025. The motion is denied. Having come for consideration in chamber on respondent's motion, court having reviewed the court file and being duly advised in the premises finds and orders as follows. Motion is denied. Respondent cites no statutory or other legal authority for the relief being requested. Done and ordered 28th day of April. Again, sent to Sarah at the wrong address that she did not update. And then the other requisite parties. And I will have to say, like, whoever is helping Sarah is not that bright, because why would you on the same day file a notice dragging her former attorney who worked for free and then fix your lips to ask for another free attorney? We've all seen what you did to 4 attorneys, dragged all of them, said horrible things, called them unethical. This one with James Owens, you threatened, not even threatened, you wrote the bar on him. Who in their right mind would give you anything? You appreciate nothing. Like, humble yourself. So yeah, that don't get me started. But yeah, so that is that. That was This, whoa, my finger's disappearing. This judge. There we go. This judge was like, ma'am, have several seats. This judge grew up in the foster care system. Like recently, her adoptive mom or her foster mom officially adopted her, like as an adult. Prior to her winning her judgeship, is it judgeship? Judgership? I don't know. Um, so in family court, they put what is in the best interest of the child. That is what family court is for. For the alimony, the child support, all of that. What is in the best interest of the child? So I feel like this judge is going to get it right because she can see through the BS. She can see that Sarah is out for self and not out for her child. Who out for their child is going to ask the sole parent raising that child to send them $61,000 when they haven't had a job for 3 years? You see what I'm saying? Like Sarah can narrate that any way she wants to, but I feel like this judge will see it for exactly what it is. Bullshit. So we'll see. We will see. We'll see if she gets her documents in. Shout out to Just a Lazy Gamer or a Lazy Gamer. You guys know who I'm talking about. It's early. It's like 5:41 in the morning. I'm trying to get this done before the little one wakes up. But yeah, he was the one who told me that things were posted today, so I sent him a copy. So check out his channel. I'm sure he's got some interesting commentary on it. And one day he and I will get together to do a collab when it's right. But yeah, let me know your thoughts. I'm so over Sarah, but I gotta quit her. I think I need a 12-step program. Like I fell asleep reading all this last night to prepare this video and I just can't put it down. It's just like I feel like I'm Brian and she's attacking me. Like, let me raise my child. You've done enough. You have done enough. Do your time. Leave us alone. Thoughts? If you guys have different thoughts, I'm open to hearing it. We can robustly, respectfully disagree. Let's talk about it in the comments. I'll talk to you later. Toodles.